All right. Time for another exciting lesson on lawsuits, collection lawsuits. I guess that's where people want me to take this thing for a while, just talk about collection activity of debt collectors and how I combat that. So today we're talking about consequences. The consequences of not answering a lawsuit are something you have to deal with when your client calls you up frantic because they've been garnished. So you'll more likely hear about a garnishment than you will a default. Like everybody else, and I've been there myself, we tend to put our head in the sand towards negative situations and we just try to focus on the happy stuff. But both have consequences. And sometimes the happy is the bad and the bad is the good because the good enlightens you and you learn a life lesson. But I digress. This video is in podcast. Both the podcast and the video are taped at the same time, obviously. Um, this is for informational purposes and for educational purposes, and you're getting insights to the wild and wacky mind of somebody that's been doing this for 30 years and seen just about everything. But I expect something else to come around, and that's the life growth when something new happens and how you react to it. When you stop reacting to things or stop wanting to, life is over. Um, but I get up every day just excited by the opportunities that will be facing me. Um, so, and I want you to feel that way too. And if you're in the right business, as I have preached in a couple of videos now, you'll do well and you'll be very creative. So, a dark area to go into is what's called default and garnishment collections. Generally, defaults come from not answering the lawsuit. There are three ways to serve or be served a lawsuit. One is personal service, and that's where a man or a woman hands you the lawsuit and says you've been served. I always tell my clients or ask my clients at this stage, tell me everything that person said to you. For example, um, process servers aren't covered under the FDCPA or the Fair Debt Collection Practices Act. There's the statute is actually codified to cut out liability for process servers because they're not collecting debts. And I've been back and forth with courts with this, but they're actually just doing their job and serving process. They shouldn't have liability. However, I always question my clients and attorneys, you should too. Has the um, process server focused on your lawsuit? Is it clear that lawsuit? Is it clear that they've read your lawsuit? Do they have comments to make? Do they say, hey, you better call the law firm and try to work this out? Hey, it looks like you've got a hospital debt. Me too, I've had that. Do they have people with them when they serve you? Do they make obnoxious comments? Is it clear that they've read your document? That's a gray area that I'm trying to make darker, if you will. Um, and I'm going in on that when I find the process server is taking too much participation or is getting too involved. Then he or she is not excluded from the Debt Collection Practices Act, FDCPA, I would argue, because they're actually collecting and they're telling you better pay this or you better call these guys. I don't ever hear them saying, hey, you should get an attorney to fight this. I've never heard that. So who are they getting paid for? Paid by? They're getting paid by the debt collector. So there's already stuff there that's bothering me that I can use and look for gold in that mine. The other way is there's three ways to be served. Oh, by the way, there's show notes as always on my videos. So not wanting to go through this again, I hope to be only 30 minutes. You can, or accompanying this, you can go through my show notes at collectionstopper.com. Go to the podcast plus and you will see so much there. How to answer lawsuits, the different unique ways that I answer lawsuits, exhibits. I'm also adding affidavits and dispute letters for the credit reports. I'm also adding validation letters, not just one, not just two, but dozens, all fitting your needs, free. You just go to the website and pick them up. We're going to be a one-stop machine for anybody that's seeking information and assistance and help. Um, so go to Podcast Plus if you want these show notes. Look around the website to see all this other stuff. It's really, to be honest with you, I was quite surprised some of the good stuff that's on there. It's been a while, but I've been adding tons of stuff to help you help yourself, or if you're an attorney, help your clients. Secondly, if you or if someone like the process server says to the court, hey, they're purposely avoiding service. I knew they're in there, but they wouldn't come to the door. Or they'll just make an allegation to the court that you won't accept service. Then they will seek what's called, in most jurisdictions, service alternate to personal service. So they're going to seek an order from the court that says, hey, we can't do the full due process here. We've tried, and the defendant won't cooperate. So the court will sign off an order, and I've attached an order for alternate service inside my show notes. I'm pointing my show notes. Um, and it will say that they, to equal the due process um, analysis and approach of personal service, they must tack to the door, and they usually take a big piece of blue tape and attach this complaint to the door so all the neighbors can see it. They then must certify it and send it certified. And they must do it three ways. They must also just send it in regular mail. So commonly a client will call me up and go, hey, this is on my door, help me out. I'll answer. And so now client can't be bothered or approached because they're represented under the FDCPA. And then there'll be a knock at the door with a postman or somebody serving them again. Well, that's allowed under the order for alternate service, whereas normally a debt collector contacting a represented consumer is breaking the law by doing that. Again, it's taped to the door, it's all over the place. Most debt collectors don't do it all at once, and sometimes it takes weeks to get the three things done. On a side note, if a client is getting knocks at the doors and knows they're about to service, I counsel them that, listen, they're going to get you either way. Accept the personal service, meet the the process server always leaves their card on the door. So I tell my clients either meet the process server away from the house, and they'll do that. They just want to get paid for their process serving. Or if you're hiring me, I'll accept service for you. And that actually slows things down once I get the um, lawsuit, but it also makes things safer for my client who maybe doesn't want to be banged on the door at all hours of the day or frighten the kids or something like that. So you as an attorney can do your client a good service by just accepting service. I've gotten it down to a science now. If someone hires me to accept service, a lot of times I'll just call up the law firm and go, before I go through all this, how about we just settle this and you walk away from the whole thing? And that happens sometimes. It's gotten to be so repetitive and they know who I am and what I can do. It's a machine for them that I cause real problems for, and they don't want that. So, attorneys, lesson there, be a problem. I know that sounds weird, but the more people just want to get along and they want peace. And if you are always a problem, I know this sounds unusual, the bigger problem that you are perceived to be, the better attorney you are for your clients. I wouldn't make stuff up. You can be a big problem just by saying, hey, the law says this. Why aren't you following the law? And be consistent about that. And that's as big a problem as you can be because some unscrupulous debt collectors rules are flexible. Well, not for me. So be a pain in the neck. It serves everybody well, and it saves you a lot of time. Um, one of I partnered with somebody for not very long, but she was one of the most influential attorneys on me, and she used to say, "Hey, look, even if you lose a case, let them regret dueling with you and let them not want to see you again on any other case. So even if you lose, and again, that's my Parker rule there, always be arguing future cases." And she was one of the best attorneys, and other attorneys didn't want to go anywhere near her. If she showed up on a file, they knew they were in for a fight. And boy, was she respected, but I'll never forget that. Make them think, I don't want to see this guy again. Just follow, and all you're doing is following the rules. And so you can settle cases by being a big pain. Um, the third way to serve somebody is just plain old certified mail. There are jurisdictions that say you can just send certified mail. When I say jurisdictions, I mean other states, depending on the state you're in. You can just send someone, a debt collector can send certified mail, return receipt requested. Means the debtor has to sign for the lawsuit. And as long as they do and everything's okay, that's acceptable service. Interestingly, debt collectors argue the best way to serve someone is personal, and the worst way to serve someone is the one I just mentioned, just by certified mail. But the court rules, especially in Michigan, don't have any favorites. The rule, I think it's MCR 2.105, just for Michigan, that says if you're going to serve someone personally, fine. If you're going to serve someone this lower way of certified mail, fine. It does not prioritize. It doesn't say one's better than the other. And I tell courts, well, if it's good enough for the people that created this, the Supreme Court, it's good enough for me, depending on what I'm going in on the debt collector for as far as service. Interestingly, the amount paid to serve someone personally, which debt collectors love. Now, debt collectors are always watching their pennies. Heck, they pay pennies on the dollar for everything they buy, but their margins get smaller and smaller. Um, so they watch their pennies, but they pay 3 times as much to serve someone personally than they do by certified mail. Why do they incur that cost? Well, they want to have their guy serve and then tell the court, hey, he was served. But there's another thing. When you opt, when the debt collector opts to hire somebody to serve another or to use another method, it's more expensive to personally serve, but the cost is pushed on to the consumer. And by the way, if I'm paying 3 times as much for something, I'll go for the cheaper thing. That's called America. It's the marketplace. Yet you are forced to pay for the approach they serve you with under the court rules by the debt collector. The law says we chose personal service, you got to pay us $50. And that gets interest, that gets charges, it gets to be a real messy. Nowhere else in America do you not have a choice about how much you're going to pay for something you're buying or paying for. So that's an area that I've slowly been moving into. So no matter what approach they use, if they can prove they served you and you don't answer, and the client doesn't answer the lawsuit in 21 days, worst thing that can happen is get a default. Out of defaults come so many consequences. The worst consequence is, I gotta have a drink here. The worst consequence is you may have the best defense to a lawsuit. It's the best defense there is. There's pictures showing that you didn't do anything wrong. But if you let a lawsuit go into default, you no longer have a right to bring a defense. The rules just about in every state say you can't bring anything else into that case. You can't do anything in that case once there's a default. That's one consequence. Um, it turns into what's called a default judgment thereafter, sometimes at the same time, depending on the court or the jurisdiction. And so now, generally 21 days after they've got a default judgment, you've got garnishments on the way. And the name of this video, which I should have said at the beginning, is Default Judgments and Garnishments. And again, look for the show notes, Default Judgments and Garnishments. Again, don't answer the lawsuit. Now you're facing default. Um, you're facing a collection machine. It's you against a very large company that's filing hundreds of thousands of debt collection cases, and it's a machine. Um, Try calling a debt collector when you get a lawsuit. And commonly, that's what happens. Clients will call the debt collector to work it out. Well, what I've noticed, a couple of things. There's actually a debt collector that does this here, a large one. Their phone system sucks. You can't get through. Sometimes that frustrates people and they just say, to heck with it. They get defaulted. I think their phone system, because I've tried calling, is purposely set up so it delays things. Another thing that is common, without pointing fingers at who does this, debt collectors will, if you do get a hold of them, they'll start negotiations with the client, unrepresented client, into settling the case. And they'll just delay. This is what I call their deal and delay approach. They'll keep dealing, they'll make promises. Hey, how about 50% off? And the debtor will go along with this, and suddenly the time period, let's say it's 21 days, is over. The debt collector will just default the person. So now they owe everything plus the fees and costs. There's no good faith in debt collection. So get a hold of your client and your client should get a hold of you before the witching hour, the 21 days is over, because the whole thing is set up, I believe, to there's this huge machine to make sure there's a default. 80 to 90% of collection lawsuits end in a default. And defaults are the gifts that just keep on giving. They're annuities. I remember as a younger attorney, I'd see these lawsuits. People would come to me and I wouldn't take them because I didn't want to charge the clients. They were for $500 or for $1,000. And I wasn't going to charge a client, and I just can't take free cases all day long. Then I'm available to nobody. Why do they file such small, relatively small cases of $1,000? Because it's the default possibility. If it's 80 to 90% default is going to happen on a lawsuit, that $1,000 default starts to add up real fast. And soon it's $5,000 and I saw a $5,000 debt turn into $40,000. It was like 15 years out, but that's that's some growth, man. And the reason why that's the case and why it's so attractive to debt collectors is a debt is based upon the paper. So if you have a credit card, the interest rate, let's say it's 18%, continues after default. They can't charge more than the interest rate of the original agreement, but they certainly won't charge less. So that's an 18% it's an annuity. These things are annuities to debt collectors. So they'll do $1,000, maybe even take a loss having to get into a judgment. But eventually the stuff adds up. So what they do is they sit on a judgment, and it's $1,000, and they wait. They wait a couple of years, and now, as fortunately with second chances and people working hard, this debtor with the $1,000 judgment gets himself in better shape, and now he's buying cars and applying for a house. Well, the debt collector keeps an eye on the credit, and as soon as they see that this is going on, they swoop in. Now the $1,000 debt is $5,000. So now the credit scores that the poor client had built up start to go down. He's got collections on their credit. Now this is another thing to deal with, and it's thousands of dollars more. So I'm coming at you as far as the consequences of not answering the lawsuit. So, what's to be done? There's a number of approaches. I'm going to say 20% of my business is dealing on the other side of a default. People come to me, they're facing huge judgments or garnishments. Um, the way to get somebody out of a default or a default judgment uh, is actually, under the right circumstances, easy. You got to keep in mind the rules say that once that default is entered, no more defenses are coming in. And sometimes a client says, "Hey, I got defaulted and now I'm getting garnished, but I was never the right person. I never signed up for that. My mother did." Um, Now they're screwed because they did not answer the lawsuit. Now they can get out of that, but that's dependent on a couple of factors. The closer that you file a motion to set aside a default to the actual date of default, the more likely that you will win that motion. Judges, you can't push them, but they want their constituents, these are the people that they serve in their district, to have their day in court. They want defendants to have their day in court. So as long as the default occurred close to the time that you filed a motion to set aside the default, and by the way, that's the only way to get those wonderful defenses you have against the case or the debt is to get a default set aside. If you keep the default, you don't have defenses. So the rules actually say within a certain time limit, you can just get this thing set aside. And again, judges will set things aside. Now, if you start getting into months, and I think the court rules in Michigan actually talk about year being the absolute time limit under certain circumstances. Um, the one approach you should look at is when setting aside defaults, is that defaults are really the genesis of all collection activity. If you kill one of the collection approaches of the debt collector, it doesn't make the default go away. So you can win in other areas where the debt collector, and we'll go over those, is doing stuff to the debtor, but still the default exists. You got to cut off the head of the snake, not the body parts. Um, those body parts are one option that clients are prone to, and again is the reason and motivation to call me, is they're getting garnished. And that means somebody is taking their wages a piece or their bank accounts, sometimes all. And that's an alert to finally do something. They may have watched this thing happen all the way along, and then something hit them, their pocket, in the pocket. So when a garnishment comes along, there's options for the garnishment. But keep in mind, again, I'm chopping off, if I fix the garnishment, I'm only chopping off parts of the snake's body. The head still lives. So if it is a garnishment, there is a default first. That's what we got to worry about, the venom of the default. You have a statutory amount of time to object to a garnishment. If you object to a garnishment, or if your client objects to a garnishment within that statutory time limit, what happens is you stop the garnishee defendant. The employee is called the garnishee defendant. and they must pass this money on to the debt collector, the garnishor, or a lot of the court rules are the garnishee defendant, your employer or your bank, becomes the debtor. They owe the whole debt for you now. So they're your friends down at the bank. They're not your friends anymore. Their whole thing is get this debt paid. So when you file an objection to garnishment within the proper time limit, you must get 3 copies. Make 3 copies of your objection, file it on the court, serve it on the debt collector, and then serve it on the employer or bank or whoever's taking or holding your money or property. Because if you don't do that, they have a 28-day statutory limit. Once the 28 days is over, they send the money to the bad guy or the debt collector. And they don't care about you. They just want to make sure they're not on the hook for the whole thing. That's one of the reasons they don't care about you. You're sort of the enemy now, the garnishee enemy. If you miss the time limit, go ahead and file your objection anyway. The rules say you still get to object. Now, what does object mean? It means you object to the court. In fact, the form that you fill out, it's online in most jurisdictions, says you're objecting, why did you object, and have a good faith reason. And then it'll say, we'll set a hearing for you. You still get your hearing whether you missed the time limit or you didn't. If you miss the time limit, they, bank or employer, then is allowed to send the money without fear that they're going against your right to object because you missed the time limit. If you miss the time limit, they'll eventually send the money, but you still get your hearing. That has many consequences for you too. Benefits. That puts the debt collector on alert that you're taking this seriously and you're objecting. A lot of the times the debt collector knows they did something wrong. From day one, they're up to something. Just look at their lawsuits, and they don't want their stuff analyzed or under a microscope of a judge. That's an opportunity for you to, or attorney, to negotiate a settlement of that debt. Even though the money from the bank or the employee is going over, you can make a deal. And this is common. Hey, if we settle this for 5,000 minus the $1,000 that's going over, 4,000, boom, case is done. It's a little bit of math, kind of a little bit of fun, actually, especially if you know the other side has done something wrong. A second approach, uh, and this is kind of cool. I did this. Cool I mean, there's fewer victories than bad days. And this was a victory for me, generally, specifically for consumers in Michigan. I had a case, it was the first one of its kind, where the court ruled yes, post default and garnishment activity by a debt collector is regulated by the FDCPA. So if they do something hinky and the case is closed, logically, if a case is closed, you're not really even acting on that case. But I got this first of its kind case, and I put it in the show notes. It's called Diaz versus G. Reynolds Sims and Associates from 2011. And I'm reading, so that's why I'm looking down. This appears to be an issue of first impression in this circuit. Neither party points to a Sixth Circuit precedent. And the court held that post judgment activity by a debt collector is FDCPA worthy, and you can go after them and get money damages, or more importantly or better for you, it's a chip. You can negotiate now with the debt collector without having to file all lawsuits and everything. But if they did do something wrong, you can file a lawsuit. And okay, so I'm going to tell you every once in a while, I'll tell you a tip that isn't covered, or I shouldn't say it isn't disallowed, but it's just Parker's way of looking at things. So you can't go and argue any defenses you have in a garnishment proceeding. So you've filed your objection, You're going to go before the court and say, hey, they shouldn't garnish me, and you'll have XYZ reasons. But you can't argue and combine it with a set aside motion of the default. Please keep in mind, and there's a reason for this, default motions and garnishment objections should be separated. All right. So what I do, how I get them together again, I file an FDCPA action, if I have one, against the collector in the same court that the default exists. I'm not going after the default, separate case. And indeed, it's a separate case, but it ends up with the same judge. And now the judge is talking about the other case, and he looks at it as a chance to solve two problems. And my little case kind of comes in, and now we're negotiating to get rid of the default that I have no right setting aside because I haven't filed it. So you're allowed to file an FDCPA action in a state court. I'm filing it because they broke the law in collecting on the debt when they garnished, separate from what the original state court case was. I mentioned that case in my lawsuit. I can do that because that's why I'm before the court in this new case. And it eventually all meshes together. And this is knowing people, knowing courts, knowing life. You just got to know how people really react to things. And it's within the rules. You're filing something within the rules in a good faith. And it's a good way to get the thing resolved. And the debt collector knows it. They know they're being sued and they sued. So someone will call me up and go, let's just settle both of these. And we do. And that's for the client. So, how one gets out of, um, hmm, how one gets out of garnishments and how one gets out of judgments are separate approaches. One is easier than the other. It's an easier case to get out of the garnishment. It's a harder case to get out the default of the default, depending on when the default occurred. Um, Again, we're going back to if you get rid of the default, you get rid of all the other court actions, the body of the snake. Kill the head, the default, and you kill everything else. So unfortunately, stay with me now, you only have a certain amount of days to object to the garnishment and keep your money, meaning keep it locked in where it doesn't go over to the debt collector. File that first, your objection first. You can then file, and it's another Parker tip, then file your motion to set aside the default, which will get meshed in together, even though they're two separate things. If you file them the relatively at the same time, the court usually will set, because it's the same case but different motions, both things on the same day, and then the court smartly will hear the arguments on the motion to set aside the default judgment, because it knows you kill that, you kill the rest of the snake, and it doesn't have to do the work for the garnishment. And by the way, if a judge does that, the judge may be tipping you off too, that, yeah, I'm probably going to go your way. And they want to do the right thing, but you've got to have the right reasons. If you are being garnished, and this is common, by the way, or you're losing your paycheck because your dad has the same name as you and he has the default and the judgment, and this is very common, you've got a good faith reason why you should get out of that default. Um, Keep in mind the thing is closed to you doing anything about it. So you want to get that default out of there. Generally, you have to, it seems easy that, hey, I'm the wrong guy and yet you took my money. It should be easy that you can just go, hey, court, look at this. No, you can't present defenses. You've got to get the motion to set aside. The key in a motion to set aside is the affidavit. I always make sure my clients have signed an affidavit saying a couple of things. Not me, it's not my debt. Uh, if I was allowed to argue this case, and you have to do that, it's called the meritorious defense part of the set aside. If I was allowed to argue this case, I would win this case. You've got to say that. You've also got to say, I had a good faith reason for not answering this. And you've got to have that. It's a two-part system. There's another part of the default judgment rule to set aside that isn't quite as strict, but judges tend to mesh those rules together and ask you. It's lot like here's the hearsay exception. It's gotten to the point now where the exception is eating the rule. The general rule is nothing's coming in with hearsay, but there are exceptions. An exception means 1 out of 10, maybe. But again, the exceptions are swallowing the general rule now. And that's what's happening here with defaults. And again, I think it's the good feelings and good motivations of the courts that just want to help you get out of this default. Again, if you're filing for a motion to set aside 10 years later, I think I've won one of those. It's got to be under what's called extraordinary circumstances. Let's say you got defaulted, you moved to Thailand. I had one of those. And then you come back 10 years later, and now you're facing a monstrous debt. Generally, you're not going to get out that. The court rules even themselves say after a year, it better be extraordinary. Most case law focuses on extraordinary reasons why that should get a set aside. So you're going to hear from clients a lot of times for the first time on the wrong side of a lawsuit. And that's sad. Um, Mistaken identity is a good reason. A lot of times, a debt collector buying an old debt serves it on the wrong house, but it doesn't care. It just claims, well, this is the only information I had. And now you may not know about this debt because they'll immediately put it into a default judgment. And you're in trouble now. You've sent some, you're applying for this security clearance and they discover you got a judgment on your record. The way to win or to apply for a motion to set aside on older debts is to show specific proof. And this is weird because I'm going to show you the absence of a proof, but show specific proof that you did not know about this debt. So if you have not lived at the place they serve for 5 years, and there's no evidence they went after your bank account or anything like that or alerted you, you can get out of that debt. But it's got to be proof that you could beat the case. If it's your debt, they just had the wrong address. That's not a meritorious defense. However, Parker would argue because they served such a crappy lawsuit on you expecting a default, then there's no real evidence for you to figure out what you're being sued for. Therefore, you would beat this because the test is the original debt properly owned by the debt collector? And you can say, no, here's the complaint, Your Honor. It's 2 pages. There's no assignments or anything. Even if even if you do owe the debt. Again, the rule is in your arguments, Your Honor, I may owe the debt. I don't owe it to this company. And if they can't prove it, that's on them. That's not on you. So file your objection motion first. Quickly follow up with your motion to set aside. I've put on, with my show notes, two forms of service of process, meaning I'm showing you what when someone serves you personally, they file a form. When someone serves you by order of alternate service, there's a form showing that. Again, this word genesis, the genesis of any default set aside is the proof of service. So, first thing I tell my clients, you should too. You got a default, you're unsure of this, you've lived there, same place for 5 years, no one's bothered you on this. First thing you do is run to the courthouse and get the court file. The court file will have wonderful things in there. And if the debt collector has told the court that it served you on a Wednesday, July 15th, and you're 6 feet tall with brown hair, and none of those things are true, hey, file your affidavit saying none of those pictures, things are true. Here's a picture of me. I'm a short guy and I've got blonde hair. Uh, Catching the debt collector with that kind of stuff where they really did bad things really pisses judges off because no matter what political state of our country, due process of law is still strong. Denying someone their due process of law is something that even kids know we're entitled to. We're entitled to know why are we suffering for something? Why are we being violation? We're entitled to know that law, and taking away the opportunity to answer a lawsuit because the debt collector wanted to get that default. Because that's the thing, man. That annuity starts when they get the default. Don't kid yourself. The annuity starts when they get the default. They want that default as fast as possible, and they'll do whatever it takes. Weird phone systems, ignoring you, making phony deals. That's who you're dealing with. If you don't like it, as I say in other videos, go do wills and trusts or go work for your uncle. These are tough people, and you got to bully a bully. So there's many options. That's what I want you to know. Uh, Timing is everything. Timing is everything. You don't want your clients falling into default. It's the worst thing. It's hard work, and you've got to kind of charge your clients more than you may want to. And again, think about this. It's an annuity for debt collectors. They want that judgment because it grows up and gets bigger. All right. Again, check out my website, collectionstopper.com. Look at my show notes. Again, there's tons of answers on there. I've put in tons of affidavits. So if you're on this side of the V or this side of the default where you've got to go do something, it all starts with the affidavit. Actually, again, it all starts with the proof of service. Go grab that proof of service and make sure you have your client fill out an affidavit saying, here's my defense, here's my reason for not answering the lawsuit. It's not even my debt. And either have them notarize that or have the affidavit, which all of mine do now, say this is being signed under penalty of perjury. You can avoid the notary by having that. And you'll see in my free forms, I've quoted a federal statute to make that notarized, if you will. So go get them. If this was useful, subscribe. If I missed something or you want me to talk about something else, I'm all ears. Remember, I always say one mouth, two ears. Listen to your clients. You can get them out of some serious stuff just by listening, just by having them do a little bit of work, just by you knowing the timing of everything. Timing is everything. And I hope you had a beneficial time here. Subscribe, like, do whatever you want. Go to collectionstopper.com. There's a ton of stuff you can use on there, and it's free. Who doesn't like free? Thank you again.